The Supreme Court just rejected a secret emergency appeal tied to Melania Trump. No explanation, no debate, no warning. But what happened next shocked legal experts in Washington. A subpoena, a sudden legal move, and a fight that could test whether anyone is truly above the law. The Supreme Court of the United States has quietly rejected an emergency appeal connected to Melania Trump, and the legal consequences are already sending waves through Washington. There was no written opinion, no public debate, and no noted dissent, just a short entry on the court's docket. But what happened after that decision has caught legal analysts completely off guard. At the center of the issue is a federal investigation into how money raised for the 2017 presidential inauguration was used. More than $100 million flowed into the Trump Inaugural Committee, a nonprofit organization created to manage the historic event. In theory, those funds were supposed to pay for security, venues, ceremonies, and public celebrations. In practice, questions quickly emerged about where some of that money actually went. Back in 2020, the District of Columbia Attorney General filed a civil lawsuit claiming that the inaugural committee improperly paid over $1 million to the Trump Hotel in Washington for event space and services at inflated prices. The case later settled in 2022, with the Trump Organization agreeing to return $750,000 to nonprofit groups. While that settlement closed the civil matter, it did not end federal scrutiny. Prosecutors continued reviewing financial records and transactions connected to the inauguration. As part of that investigation, a federal grand jury issued subpoenas for documents and testimony. One of those subpoenas went to Melania Trump. That alone is significant. The Justice Department does not casually subpoena close family members of a former president. Internal rules require senior-level approval to make sure the move is based on legitimate investigative needs, not politics. In other words, multiple officials had to agree there was real reason to seek her testimony. Melania Trump's legal team immediately pushed back. They argued executive privilege, spousal protections, and constitutional limits on what prosecutors could demand. A district court rejected those arguments. An appeals court agreed with the lower court. Her lawyers then rushed to the Supreme Court, asking for an emergency stay to block enforcement of the subpoena while further appeals were pursued. The Supreme Court said no. When the court denies an emergency application without comment, it is not technically ruling on the full case, but it is signaling something important. The lower courts handled the issue correctly, and there is no urgent legal problem requiring intervention. The justices could have paused the process to allow more briefing. They chose not to. That tells legal observers the subpoena stands. The legal theory behind the appeal was ambitious. Melania Trump's attorneys argued that as a former First Lady, she deserved special protection from being forced to testify about matters connected to her husband's presidency. History, however, cuts the other way. In United States v. Nixon, the court ruled executive privilege cannot hide evidence in criminal investigations. In Clinton v. Jones, it held presidents are not immune from civil lawsuits for unofficial conduct. In Trump v. Vance, the court confirmed that even presidents can be subject to criminal subpoenas. Together, those cases establish a clear rule: political power does not cancel legal accountability. After losing at the Supreme Court, most witnesses comply. That's what normally happens. But this case took a surprising turn. Instead of appearing before the grand jury, Melania Trump's legal team filed a new motion in district court. This time, they raised a jurisdictional argument, suggesting that her foreign ties and legal status limit U.S. court authority over her. Legal experts immediately flagged the move as unusual. Jurisdiction challenges are normally raised at the very beginning of a case, not after district courts, appeals courts, and the Supreme Court have already weighed in. Raising it now looks less like a discovery of new law and more like a strategy to delay compliance. In federal practice, late jurisdiction claims face a very high bar. Courts generally require clear proof that they lack authority, not simply that the process is inconvenient. Dual citizenship or international background rarely blocks a federal grand jury from compelling testimony about actions that occurred in the United States. Diplomatic immunity applies to active foreign officials, not former ceremonial figures connected to U.S. government activity. So why fight this hard? When witnesses aggressively resist subpoenas, it usually signals risk. Either the testimony could harm someone politically or legally, expose sensitive financial details, or create potential criminal exposure. While witnesses can assert Fifth Amendment rights, they still must appear and answer permissible questions. History offers contrast. Ivanka Trump and Donald Trump Jr. both complied with federal subpoenas. Jared Kushner did the same in prior investigations. Legal review happened, then testimony followed. What makes this situation different is the length and intensity of resistance. Public court records already show that Melania Trump was involved in planning inaugural events. Emails indicate she approved vendors, coordinated logistics, and communicated with committee staff. That makes her a fact witness, someone with first-hand knowledge of how decisions were made and how money was spent. For prosecutors examining financial irregularities, that type of witness is critical. Grand juries are one of the pillars of the American justice system. They decide whether there is probable cause to believe a crime occurred. But they can only function if witnesses follow subpoenas. If powerful individuals can delay indefinitely through procedural warfare, the system weakens for everyone else. The Supreme Court's rejection sends a message. The legal process applies equally, regardless of fame or political history. What happens next will test whether that principle truly holds. And this story is only just beginning. What happens next will determine more than the fate of one investigation. It will test whether the American legal system still works the way it was designed to work when power, money, and influence are involved. A federal grand jury has spoken. Lower courts have ruled. The Supreme Court has declined to interfere. At this point, the law is clear. Lawful subpoenas are not optional. They are obligations. And when someone refuses to comply, the courts have tools to respond, from financial penalties to contempt charges, and in extreme cases, criminal enforcement. For prosecutors, the stakes are high. They can push for court sanctions, they can escalate the matter, or they can attempt to build their case without direct testimony. None of those options are easy, especially when the witness is one of the most recognizable figures in modern American politics. But the larger issue goes beyond Melania Trump. It goes to the heart of accountability. In the United States, justice is supposed to be blind. It is not supposed to bend for celebrity, wealth, or political legacy. If everyday citizens must answer subpoenas, then public figures must do the same. Otherwise, the rule of law becomes selective, and selective justice is not justice at all. History shows us that moments like this define institutions. Watergate tested them. The Clinton era tested them. Recent political investigations have tested them again. Each time, the question is the same. Will the system enforce the law evenly, or will influence rewrite the rules? Right now, the machinery of justice is still turning. Motions are being filed. Judges are reviewing arguments. Prosecutors are weighing next steps. What we are watching is not just a legal battle, it is a stress test of American democracy itself. Because if subpoenas can be ignored, if investigations can be delayed forever, and if power can outlast accountability, then the real damage is not to one case, but to public trust. And once trust is gone, no court ruling can easily restore it. So this is not the end of the story, it's the moment where the story becomes important. What happens next will reveal whether the system protects truth or protects power. And that's something every citizen should be paying attention to. If you want the truth behind the headlines, if you want the stories powerful people hope you never hear, and if you want real investigations without spin, subscribe to World Dark Files. Hit the like button, share this story, and turn on notifications so you never miss what's really happening behind closed doors. Because in a world full of noise, World Dark Files brings you the facts they try to hide.